The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome back. It's Court Radio and it's Sunday morning, 7 a.m. Today is October the 11th, all day long. And guess what, folks? It's starting to get a little chilly out there. You're going out, you better cover up. You know, you hear me talk about him all the time. I defer to his wisdom. It's the one and only, my special co-host for October 11th, Saul Langsam.
Good morning to everybody. Good morning, Dean and company.
Good morning, Saul. You know, if you've got legal issues dealing with wills and estates, you better call Saul. He's even wearing the T-shirt today. So I'm glad you got here today and on time and everything. Yeah.
My pleasure.
There's a lot of stuff going on. Let's hit a few news topics before we move on to wills, estates, and other things that you're going to talk about. Did you hear that the Harvard debate team was crushed in defeat by the, let me get this prison right, the Eastern New York Correctional Facility in the Catskills fielded a debate team which beat Harvard to a pulp. Could you believe that? And you know what? The prisoners didn't even have access to the internet to prepare for the debate. They had to do it all the old-fashioned way.
Says something about the old-fashioned way, doesn't it?
I brought that up because, you know, old-fashioned, Saul. Just kidding. So, folks, if you've got legal issues today dealing with wills and estates, family members who died decades ago, you're scratching your head and wondering how to get at the cash, Saul's here to answer all those questions. All you got to do is give us a call at 215-227-2727. And when you can't call us on Court Radio between 7 and 8 on Sundays at that number, you'll get us all week long at My Philly Lawyer. And Saul loves to talk to new clients. All you got to do is give the office a call and ask for Saul. Let's see, what else is going on? Hey, I heard that a 31-year-old murder in Bucks County involving a 14-year-old girl was recently put to bed. It's amazing. They don't give up on these things. And, folks, you should know, because we talk a lot about statutes of limitation, there is no statute of limitations for murder. It is unending. As long as the parties are alive, if they solve the crime, they will prosecute you. And so they found a guy locally who told them, who had assisted in disposing of the body, told them who the murderer was, a gentleman in Florida, and they went down and got him and brought him back here and will prosecute him for the murder of this 14-year-old girl, which occurred 31 years ago. We have a woman, Brooke Hartka, is counting her blessings after a sinkhole swallowed her car Friday on the 1800 block of South Columbus Boulevard. What's sinkholes? That's a problem usually in Florida. We talk about insurance on cars. No insurance and a car gets swallowed up. Do you think there's a potential cause of action against a third party?
Unfortunately not, unless Mother Nature is not accountable.
Yeah. You'd have to prove that, I guess, that the city somehow had notice of this problem and failed to take corrective measures, perhaps. But it would be a tall order indeed, and far easier if you had property damage insurance. But if you have questions about insurance, you know, I do from time to time take some time out of my day to meet with, you know, prospective clients or just listeners to Court Radio to review their insurance contracts. Saul, you do the same thing.
Yes, we do. I think it's important. We're in the legal community, we're not convinced that the insurance industry is giving their customers an accurate understanding of the options available to them. So it's important that you get a disinterested party who's not selling you the insurance or earning a commission to tell you what is or isn't important.
There you go. I couldn't say it better, except that I'm not sure. I think that the insurance industry is more culpable in the failure to provide the information than Saul points out. I think that they intentionally withhold information from customers just to sell them a policy which provides as little protection and coverage as possible so that their profit margin is great. Why give somebody coverage they might actually use when you can sell them coverage they'll rarely use and pretty much charge them the same amount? But we'll set you straight. You know, if you bring your policy in, we'll be happy to sit down with you and explain to you in no uncertain terms what you got and what you don't have. Just give us a call at 215-227-2727 during the week and ask for your insurance review. I'll sit down with you. Absolutely. Folks, if you're listening and you're following Twitter, you can follow us on Twitter at Court Radio. You know, Monica, producer supreme, is constantly tweeting. All right, let's take a call, Saul.
Okay.
Because we have them lining up. Let's talk to Debbie from South Philly on line 2. Debbie, welcome to Court Radio. Hi, how are you?
Good morning. How you doing? Fine.
Good.
I'm calling because my mother left her will, naming my 4 siblings and my son in the will. Now, there was an insurance policy and there was money left in the bank account, which my other siblings, they took the death certificate and cashed them in, and the money wasn't divided with the other individuals. Do I have a legal case to bring them to court?
Well, okay. There's a lot of questions there. Let's try to tease this out. You have a will, and you have 4 siblings, and your son as the beneficiaries of that will. Therefore, anything that gets passed to the family, to the beneficiaries through that will, can be contested by one of those family members. Now, if you, as an intestate heir, okay, want to say that the will was entered into fraudulently, or that your mother didn't have her faculties at the time that she entered into the will, I suppose you potentially could contest that will as well. But then the insurance policy, Saul, insurance policies are treated differently, correct?
Yeah, insurance policies are our contracts, and you're guided by the language of the contract. The insurance policy will identify the beneficiaries, and those beneficiaries are entitled to the proceeds. And if you're not named as a beneficiary, you do not have a claim.
And being a beneficiary under the will doesn't necessarily mean you're a beneficiary under the insurance contract. So you have 4 siblings and your son, or a total of 5 beneficiaries under the will. But the contract for insurance could pass to only 2 beneficiaries, or 1 beneficiary, or none of those and a whole different one. So, you know, you have to look at who the beneficiaries were under the insurance contract. And usually the insurance company will not disperse the funds, will disperse the funds to those that are listed as beneficiaries. So if only 2 family members, for instance, took the money from the insurance contract, there's probably a decent chance that they're the only 2 listed as beneficiaries.
It's important to understand in Pennsylvania that a child has no legal standing if their name does not appear in the will of a parent. There's no legal responsibility that a parent has to leave to a child. If the child's name is not included, that child does not have any standing unless, as Dean indicated, you can prove that the will is vulnerable to either a claim for undue influence or lack of capacity.
Does that answer your question, Debbie?
Well, everybody was listed on the insurance policy. All her children were listed on the insurance policy.
Well, if they were, if all the children were listed and you have proof of that, and some of the children didn't receive their fair share, then those children would have a claim against the insurance company for failing to disperse the funds according to the terms of the contract. So if 5 of you are listed on that insurance contract and you're each entitled to $10,000 or 20% of a $50,000 policy, say, and they gave all the money to 1 or 2 people and none to the rest, absolutely the children who were left out have a claim. And they could sue the insurance company for failing to properly disperse those funds.
Okay, then that's what I wanted to know. I was going after the executor because it was my older sister. She was the executor, and she handled everything, and she got the money. And
right. Well, I'm going to say this one more time so everybody understands. The monies that come from the insurance contract are treated different and separate. They do not pass through the estate. The executor does not get their hands on the money from the insurance contract. The insurance company pays it directly to the beneficiaries, unless the beneficiary were the estate itself. You could name the estate as a beneficiary, then the money would pass through the will. But if they're actual beneficiaries listed on the contract first, they're the ones who get the money, not the executor.
That's correct.
All right, Debbie, thanks for calling Court Radio. You had some great questions there, and have a great Sunday, dear.
You too. Bye-bye.
215-227-2727. Let's talk to Bob from Sharon Hill, PA. Hey, Bob, welcome to Court Radio.
Hey, how you guys doing?
Wonderful.
You got old Sal's in the seat this morning, huh?
Yeah. We brought him out, puffed him up, and sat him down, shined him up. He's ready to go. He's ready to answer your question, Bob.
I got a good question for you, Sal.
Go right ahead.
Let me ask you a question, okay? If you are the beneficiary of the will, and before the person dies, they put you as a joint person on their bank account. When you go to probate, how do they separate on how much money is joint to you and them where they charge you the taxes on?
Well, when you're talking about bank accounts, you just have to do the mathematics. If there are 2 names on the account, the presumption is that each of the individuals owns 1/2 of the value of that account. So 2 names, 50%. If there are 3 names on a bank account, the legal presumption is that each named individual owns 1/3. So if you're looking at who's responsible to pay the inheritance tax, if that's what the language of the will says, then it's simply doing the math. If you're one of 3 owners, the inheritance tax is calculated based on your 1/3 value. So to give you a simple example, let's talk about a bank account that has $30,000 in there, and there are 3 people named jointly as the owners. Then each of those owners would be entitled to $10,000.
But only 1/3, or only the decedent's share of that bank account will pass through the estate. The others would go directly to the co-owners.
That's correct.
So Bob, if you're a joint account holder with let's say your mom, and she's got a fifth, like Saul said, that there's $30,000, $15,000 is yours. It's yours. It doesn't go through the estate. It's not hers. It's yours. They just hand you the $15,000 whenever you say, give it to me. The other $15,000, which is her property, that would go through the estate and get passed to her heirs under a will or under intestacy. And Saul and I are going to talk right now about what intestacy is. But did that answer your question, Bob?
Yeah, but the only thing I don't understand is, why is it that you have to pay a heritage tax on anything that somebody worked for all their life, and then you got to pay that money?
You're asking a very good question. Let's not lose sight of the fact that most of our governmental bodies are broke. Be that as it may, the inheritance tax, and this varies from state to state. There are some states like Florida that are community property states that don't have any inheritance tax. That's why some people move their valuables and their residences down to Florida. But in Pennsylvania, clearly there's an inheritance tax, and the amount of the inheritance tax depends on the nature of your relationship to the decedent. And there's a formula, and that formula is applied to the amount of money you're going to inherit. So when you say, why should somebody who has worked a lifetime and then has the privilege of leaving their property to loved ones, why should that amount of money be taxed? That's because of the greed of most of our governmental agencies, and since the receiving party, he or she who inherits, is realizing a windfall, Uncle Sam wants a piece of it.
Yeah. That's a question for the host following. That's a politician's question. Why tax the money? But the taxes have come down over time, have they not?
They have come down. I don't think there's been changes. There's a formula and there are percentages, but they have come down. That is correct.
And they used to tax spousal shares. They don't tax that anymore.
Correct. No inheritance tax between spouses.
So if it's your wife who passed, you don't pay anything. If it's a minor child, God forbid, who passes, I don't believe a parent pays anything. There are exceptions, but generally, and it's a very small tax, right? I mean,
it's correct. It's 4.5% of the net value of what you're inheriting.
So you get to deduct all the things that you would expect to deduct, like, the cost of the funeral and the final meal after the funeral and all those things you can deduct, the headstone, the burial, and then after you make all those deductions, then you pay 4.5% on the net proceeds. All right, Bob from Sharon Hill, you're done for today, sir.
Thank you very much, but I still think I got robbed.
Nobody's disagreeing with you.
Yeah. Well, when it comes to the government, getting robbed is a fact of life. Have a great Sunday. Thanks for calling Court Radio. Yeah, okay. He just bowed out gracefully. Click. So, we've been kind of dancing around. We've been talking about wills and intestacy. Let's first explain to folks what happens when there is no will. And that's not an uncommon scenario. A lot of people, unfortunately, don't come and see you before they pass, and they die without a will. What happens?
That is true, although I will say that the younger generations today are much more sophisticated, and they're all insisting on having wills, which makes the most sense because then they're controlling their assets. Now, to avoid all of this confusion, you leave a will because the will document basically sets forth what your wishes are, and if you don't put your wishes in writing, nobody's going to be able to read your mind. In those instances where somebody passes away and they do not leave a will, our legislature, in its infinite wisdom, came up with a scheme of distribution, and it's logical. The scheme of distribution basically says that if you pass and you do not leave a will, and you are survived by a wife, your wife is entitled to a portion of the estate depending on whether you're also survived by children. And if you have children, then your wife and your children will share. There's a formula for how they share the value of your estate. And if you are not survived by a wife and you're not survived by children, then it goes on to whether you're survived by parents, whether you're survived by siblings, and whether you're survived by nieces and nephews. So there's a pecking order. And the whole idea behind what's called intestate succession is, as our earlier caller mentioned, if you've worked a lifetime to accumulate these assets, they really should not be going to the Commonwealth of Pennsylvania as long as they can find a family member that's on the intestate succession list. That family member stands to inherit.
Okay. So, and it goes down to nieces, nephews, aunts, uncles, cousins?
Yes.
Okay.
Not cousins.
Not cousins. Okay. 215-227-2727. How long do you have to make a claim against an estate?
There is no statute. You want to get there sooner than the property escheats to the Commonwealth of Pennsylvania. Once the property, the law says that if, for example, if a bank has a bank account that's dormant, after 7 years, that bank has to turn that money over to the Pennsylvania Unclaimed Treasury Department. And most of our listening audience should be familiar, or make yourself familiar with the fact that that Treasury exists, and there are over $2 billion of monies that belong to everybody but the Commonwealth of Pennsylvania. So get online. If your name is there, there's a simple claims process. If you need us to assist you, because we're now involved in some very complicated claims processes, you can contact us. We recently recovered $33,000 for one of our clients who had an uncle that died with a life insurance policy that was not claimed, and we were able to convince the Treasury Department that this was the next rightful heir under the intestate statute.
Wow, $33,000. 215-227-2727. You got wills and estates issues. You got property you think you're entitled to. You can give us a call. How do we get paid to represent people in these matters?
It depends on what the circumstances are. In some instances, we are hired on an hourly basis. And in some instances, if we are able to confirm that there are assets that our client is entitled to, we may consider entering into a contingent arrangement where our clients pay us nothing, and our recovery, our fee is solely based on the recovery that we obtain.
Okay, that's good to know. 215-227-2727 is the number to call. You talk to Saul, he'll get you the cash. Let's talk to Mark from Warminster on line 4, Larry. Oh, Mark, welcome to
hello.
Court Radio. Welcome to Court Radio, Mark. How are you?
Oh, thank you very much. I'm doing well.
Good.
Yeah, I don't know if you're going to be able to help me or not. Real quick question. My parents both died last year. They have a house in, it's all our house, Northeast Philly. They signed the house over to the 4 siblings in 2006. Now, my youngest brother moved in there when my mom went into the hospital for her last couple of days of life, and then somehow thinks it's his house. The deed is in all 4 children's house. The deed is in all 4 children's name. Me, my older sister, my younger sister, my older brother, and him. And we're having trouble. He won't let us sell the house, and then he says he wants to buy the house, and he's been giving us like a runaround for about at least 6 months or so, just trying to get a loan, and his credit wasn't up to snuff, and then he's trying to straighten his credit out. But we all know that he's kind of giving us the runaround, dragging his feet, and this and that. And we want to just get rid of the house, and it goes for over $200,000. So,
yeah, this is unfortunately a common scenario, and one I think that should be avoided at all costs. When you have multiple parties who are beneficiaries, to put them on one will invites exactly what you're going through. A lot of litigation and a lot of aggravation because parties' needs are different from one another, and unfortunately, it drags out. But I'm going to let Saul comment because we have a case right now on this very topic.
Yeah, we have the identical fact situation as we speak right now, and one son moved in. There are 5 siblings, and he's been promising to secure a mortgage to buy out the 80% interest of his brothers and sisters. And what we sent friendly letters. They did not work. We had to resort, and it was costly, but the siblings paid. Like you said, you got a property that's worth $200,000. That means there's a lot of money that each one of the siblings are entitled to. We had to file what's called a complaint in ejectment. Complaint in ejectment in Philadelphia is filed with the Philadelphia Orphans Court, and we ultimately ended up getting an order of ejectment, which we then solicited the services of the Philadelphia sheriff to execute by literally removing the person and then changing the locks, bringing a realtor in, selling the property, and then making the distribution as per the wishes of the parent.
So you're not powerless, Mark. All you got to do is gather up your siblings and come down to the office and speak with Saul and begin this process. If that's something that you think might work, by all means, just reach out to us during the week at 215-227-2727. Remind Saul that you spoke to him on Court Radio, and he'll get you in promptly.
Okay, and that's a fee to come in and see him, I guess, right?
Yes, there's always going to be a fee.
Right.
Saul can work with you on that before you get down so you know exactly what you're looking at.
Okay.
Mark, have a great Sunday, and thanks for calling Court Radio.
Thank you. Bye-bye.
Bye now. Folks, we're going to be back in 2 minutes, 30 seconds right after these announcements.
If you have legal problems and need answers, call My Philly Lawyer, Dean Weitzman, first at 215-227-2727 for personal injury, medical malpractice, birth injury, and more. Call Dean first.
He will fight for your rights. That's what Dean Weitzman is all about.
Call My Philly Lawyer, Dean Weitzman, first. 215-227-2727. My Philly Lawyer, when winning matters most. For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning, folks, and welcome back. It's Sunday, October the 11th. I'm Dean Weitzman, and this is Court Radio. I'm joined in the studio with my co-host, you know him, the one and only, Saul Langsam. Welcome back, Saul.
Why, thank you, Dean.
You know, when Saul's here, we're talking about wills and estates. Saul's the will and estate guru at the firm. He does all the wills and estate planning and the litigation and meeting with the clients. If you've got questions, you've got issues, all you got to do is give us a call during the week at 215-227-2727 and just call Saul. So let's talk to Karen from Germantown on line 3. Karen, welcome to Court Radio.
Hey, good morning, Dean. Good morning, Saul.
Good morning.
My question is, good morning. It's not about a will and estate. I just had a common question about my insurance, and Dean, I will be making an appointment to come in. When they say full threshold, because I'm in Jersey, is it the same as carrying full insurance? I mean, full coverage?
Okay, so this is a common misconception, I think. A lot of times insurance companies will banter about the term full coverage, and people think they have all the necessary coverages and that they're fully protected. In fact, full coverage generally refers to comp, collision. It refers to all the coverages or full coverage for the automobile. But then there's a whole slew of coverages for you, for your family, for your body, for your ability to make a claim for pain and suffering. All those kinds of coverages are not contained when somebody says, I have full coverage. In Pennsylvania, it's called full tort. That gives you an unfettered right to pursue a claim for bodily injury. In New Jersey, it's usually referred to as zero threshold or no lawsuit threshold or no threshold. That's the full tort equivalent. But I need, like you said, Karen, I need to see your policy, review it carefully with you to tell you what you have and don't have. There's a lot of coverages which are not mandatory, but they're so important, like uninsured and underinsured motorist. It's estimated that half of the people driving out there in metropolitan Philadelphia area are uninsured. God forbid if one of these people strikes your vehicle and causes catastrophic injuries to you, you have no real significant right of recovery unless you maintain uninsured motorist on your car. If you do, then you can go against your own insurance company as if they were the tortfeasor's insurance, and then let them chase after the tortfeasor for the rest of his or her life. But without that coverage, without that uninsured and underinsured motorist coverage, you're really left without any significant right of recovery. And it's not mandatory coverage, though I think it should be treated as mandatory. If you've got family and yourself and you're employed, you might not be able to work following an accident. And again, without uninsured and underinsured motorist, you're really up the creek without a paddle. Karen, give me a call during the week, and I'll be happy to sit down with you and review your policy and give you some tips.
Well, thank you. Thank you. Have a good day, Dean.
All right. See you, Karen. 215-227-2727. Let's talk to Teresa from Northeast Philly. Hi, Teresa, and welcome to Court Radio.
Hi, good morning. How are you guys doing today?
We're both doing great, thanks. Where are you off to, Teresa? It sounds like you're already on the road.
I'm sorry. I'm on my way home from work, and I'm actually getting ready to park now.
Oh, okay. What do you want to...
I have my Bluetooth headset on, so I'm safe to talk if that's okay with you guys.
Oh, yeah, absolutely. And so what's your question?
Okay, my question was basically I wanted to know if my father, he's a retired police officer after 22 years, and he recently divorced my mom, and I'm his only child. He told me that when he retired from the Philly Police Department, he put his pension in the estate of his name. And he told me that once he passes away, I may be able to possibly hire a lawyer and then try to be able to earn that pension for myself since he's divorced. And he told me that when he retired from...
Say that again? Say the last part again?
The last part, basically, he told me that I may be entitled to that pension since I'm his only child and he's now divorced once he passes away. So I just want to know if you could give me any advice about that, if that's true, or if the government's just going to basically, take his pension once he passes away since he's no longer married.
Well, I guess the first question, or the real question here is there a death benefit to a pension? Is there some part of a pension which goes beyond the death of the pensioner? Saul?
As a rule, there's not. You have to take a look at the language of the policy. Pensions are created to provide the retired employee with an income stream. They're really not entitled as an inheritance for family members. Now, there may be a death benefit of some sort, a burial benefit. There may be some miscellaneous benefits. You would have to look into the language of the policy to determine what they are, if they may be available to you.
Right. So the way to plan for this is to do it now while Dad's alive, because he can provide you with the documents that you would need, that you would need to review, or for us to review. You got to look at the pension contract or documents, your dad's benefits plan, or there's some document or documents that contain what he is entitled to, and if there's any entitlement for a family member after he passes.
Okay, awesome.
All right, thank you for calling and have a great Sunday.
Thanks, you guys too. Take care.
Let's talk to Dwayne from Mount Airy. Good morning, Dwayne, and welcome to Core Radio.
Good morning, gentlemen. How are you today?
Good morning.
Good, thanks. How are you doing in Mount Airy?
Not too bad. I'm working, actually, so...
Oh, there you go. Well, you must be on your lunch break right now, huh?
Something of that nature. Quick question. I was power attorney for my mother in 2005. She was stricken with Alzheimer's, and her financial guy told me to go get a will made out, and that would, alleviate the problems we'd have later on. So he sent me to a lawyer in the Chestnut Hill area. My mom sat down, wrote up what I thought was a will. We took a copy to the bank, and years later, my mom passed last year, 2014. The bank had a copy of the will. I called the lawyer up to get a copy of the will, and he said he sent us a letter in 2005 stating that my mom didn't sign it, so it wasn't official. Yet the bank had a copy, and what my mom had in her accounts at the time split it up the three ways that my mom said that was supposed to be split. Now, I was kind of concerned because if the bank has a copy of this, but this guy said he has a copy, but my mom didn't sign it, do we have an official will, or how does this work now?
Well, it's hard to tell what you have because first you used a couple different terms. You used the term a will, but you also used the term power of attorney, and they're two completely different documents. Saul prepares powers of attorney, which gives you the right to make decisions on behalf of the person with whom you hold that power, in this case your mom, while she's alive. But the moment mom passes, the power dies with her. And so that document only works while she's alive and allows you to, sell property, write checks, enter into contracts, et cetera, et cetera. That's called a power of attorney. And we do those all the time.
We do. I'm curious, when you say that you were suffering from some type of a dementia and then the financial representative suggested that you be taken to a lawyer to prepare a will, I can tell you that if she lacked the capacity she would not legally be capable of executing a will, because the law is very clear that if you're going to sit down and sign your name to a will document, you have to read it and you have to understand it. So in the back of my mind, I'm just wondering what her mental state was. And the bank would have no interest in an unsigned will document. The only document they may retain for their records would be a properly executed power of attorney.
And who? Let me ask you this. Let me ask you this, Dwayne. Who's the beneficiary? Who's the beneficiaries under this will?
My 3 brothers, and this is what I was the power of attorney in 2005.
Right, but again,
at this time, my mom was diagnosed with the Alzheimer's, so it wasn't progressive, so she had the ability to sign and do things at that time.
Okay.
He told me to take my mom to this lawyer. My mom sat down and wrote a will, and she said she wanted everything split between her 3 sons, myself and my 2 brothers.
Well, if there's no will, Dwayne, if there's no will, then nothing changes, right, Saul?
Nothing changes. The intestate statute will make sure that you and your brothers are treated equally.
Right, with or without a will in your circumstance. With a will that gives everything to all 3 brothers, or no will, it still goes to all 3 brothers. So there's really no no great advantage in this instance. If you don't have a will, you're still going to get what you would expect to get, 1/3 of the estate. Okay. Now, and again, if you were the power of attorney when she was alive, that power dies when she dies. In order to be the person who is involved in the actual signing documents, once the person dies, that person is called an executor. That person is named in the will as an executor. What happens, Saul, in his case, if there is no will, you have 3 brothers, who becomes the executor if they can't decide?
Well, if you're entitled, the 3 brothers are entitled to get together and raise their mom's estate. Now, when you raise an estate, that's a proceeding that takes place in front of the Register of Wills. When you raise the estate, somebody has to be appointed the administrator. And amongst the 3 of you, you can agree that 1, 2, or 3 of you serve. You each have the same legal right to act as an administrator or as a co-administrator together with siblings.
Okay, so all you have to do at this point is get together with an attorney and raise the estate. Bring your brothers together. Everybody will cooperate, I hope, and each of you will share equally in the estate. And with or without a will, you should be able to get the documents you need from the court so that the banks and the real estate can be sold, transferred, and everything can be reduced to a lump sum, then divided equally amongst the 3 brothers.
Perfect. And just like your previous caller, I have a brother who thinks he's entitled to the house, so that's another story. But thank you so much for your information. I really appreciate that, gentlemen.
You're welcome.
Dwayne, take care and have a great Sunday. Get back to work.
Thank you.
215-227-2727. Saul, what's the cost for one of the Court Radio listeners who calls the office and wants to do a simple will?
We charge $250, which we discovered is a very, very conservative figure, but we've always kept it at that amount for our listeners and for our clients.
And then once somebody passes, what do we do to help in the resolution of the estate?
If the named executor or administrator of the estate reaches out to us and retains our services, we will handle all of the legal paperwork from start to finish, which includes doing some online filings in order to send a petition over to the Register of Wills office in order to open the estate. We will make the appointment and go with the client to the Register of Wills in order for her to be sworn in. We personally go over there and pick up the necessary documents. And depending on what the assets are, we will assist our client in administering the estate. Lastly, and this is also very important because anybody can walk into the Register of Wills office and open the estate, but I have to tell you, there are a multitude of documents, including a Pennsylvania inheritance tax return, a final inventory, and certifications to the Pennsylvania Supreme Court that must be filed in order for that estate to be properly closed. And that's where our many people run into problems because they open the estate and that's where they drop the ball. What happens after that is when the estate is not closed or the inheritance tax is not paid, you're going to start getting letters from the Department of Revenue and from the Register of Wills office, and the tone of those letters will change with the passage of time if you've not paid the inheritance tax and properly filed the necessary papers.
Bottom line, folks, is it really behooves everyone who's involved in a family member's passing, who's a beneficiary under that estate, to retain counsel to assist in the resolution of the estate. And you'll make sure that you get what you're entitled to as quickly as possible and all that you're entitled to, but while at the same time making sure you don't leave any loose ends. You don't have somebody chasing you from the Commonwealth or from the city of Philadelphia, 3 or 4 years from now, asking for something which perhaps you've already spent and it's gone.
Dean, I'll interrupt you for a moment. We had somebody come to us who thought they properly handled their mother's estate, only to start receiving letters from the Department of Public Welfare. There was a $105,000 lien against the estate. In the last days of their mother's life, she was in a rehabilitation facility, and DPW paid the fees because the family members did not. DPW then filed a lien against the estate.
Yeah. And, we've represented all the parties in this matter, including DPW. There have been times when DPW has retained the firm and times when, obviously, the individual litigants do. In fact, who's the Register of Wills in Philadelphia?
Ronald Donatucci.
How long have you known Ronald?
Since we graduated high school together.
So, we know who the players are. We know what's involved in bringing these matters to a successful conclusion. All you have to do is give us a call at 215-227-2727. And as Saul said, sometimes we'll even work a fee arrangement out where we take a fee from the assets of the estate once they're disposed of. When there are assets that we feel we can quickly dispose of, we're not adverse to representing folks and holding off on our fee until the matter's resolved. Okay, we've got a ton of callers, but we've got to take one more break before the hour. And folks, we'll be right back after these important announcements.
If you have legal problems and need answers, call My Philly Lawyer, Dean Weitzman, first at 215-227-2727 for personal injury, medical malpractice, birth injury, and more. Call Dean first.
He will fight for your rights. That's what Dean Weitzman is all about.
Call My Philly Lawyer, Dean Weitzman, first. 215-227-2727. My Philly Lawyer, when winning matters most. For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. It's Court Radio, and you know it, I'm Dean Weitzman, joined in the studio with my co-host, the one, the only, the inimitable Saul Langsam.
And good morning to everybody again.
There you go. If Saul's in the studio, folks, we're talking wills and estates. That's right, because that's his specialty. And he's been killing it with wills and, well, that's probably a bad word, you know. he's been taking care of clients with wills and estate issues for a long time. Let's talk to Katrina from Pottstown on line 1. Katrina, welcome to Court Radio.
Good morning.
How do you feel, Katrina, how do you feel about being named after a horrible hurricane?
Well, it was quite difficult. I did prepare a document as a cleansing mechanism for myself because, you know, people constantly talked about it, joked about it, and it was not the most pleasant thing to be associated with.
Yeah, it's like all of a sudden one day, you know, your name becomes like a synonymous with some horrible event.
Mm-hmm. The only thing good that came out of it is now people spell my name correctly. They always spelled it with a C. Now they spell it correctly.
Well, you see, you're a woman who looks for a silver lining behind every cloud.
Well, my call this morning is I'm trying to help my nieces out. Their father passed away a couple of years ago in California or Florida, and apparently the laws are different. And they were just simply trying to get the funds in order to pay for his burial. And when we contacted the local bank, they told us what we needed to do. They took care of the documents, but then once it got to Florida, they would not release the money. Then they were told that they had to go to the courthouse. They went to the courthouse and filled out the necessary paperwork, and I apologize, I don't know what the name of it is, but they filled out the documents, and here 2 years later, they still have not been able to retrieve the funds. Fortunately, the 401k was listed and they were beneficiaries, so they managed to borrow money in order to pay for the funeral, and then they paid those individuals back. But now we still have this money sitting at the bank, which they have not been able to retrieve.
How much money is in the banks in Florida?
It's a little over $20,000.
Okay. Well, and the reason I ask that is because it's probably a fairly routine matter to get to that money if you retain Florida counsel. And you bring up a very important point, and one that Saul touched upon earlier, and that is that each state has their own laws, their own requirements for what needs to be filed and how it needs to be filed. And it's even though, let's say, for instance, the person passed in Pennsylvania, if they have property in other parts of the country, you have to comply with the laws in each jurisdiction. And with $20,000 at stake, I mean, you know, I can't imagine this is more than maybe $1,000 worth of legal work, if that, to get that money. But the question is, where was the estate raised? Here in Pennsylvania?
No, unfortunately, there was no estate.
Aha. So where did the person reside when they died?
In Florida.
Okay. Yeah, I think that the best advice I can give you, because I didn't hear you say this, is to retain Florida counsel.
There, some of the jurisdictions will streamline the process depending on the value of the assets. If you have what's called a small estate, where, let's say, the value of the assets is under a designated amount of money, is a very, very simple process for getting an order allowing the funds to be released.
I also think that you'll probably be able to retain that attorney in Florida with a signed promise to pay from the proceeds of the bank account. That, they're not going to have to come. The kids aren't going to have to come to the table with money in hand to make this work. And that seems to me that if there was, if I had to give some advice, that would be it. To have somebody retain counsel in the county in which the decedent resided when he died, and because it's important to do that in the county that they resided, because like here in Pennsylvania, if you live and die in Montgomery County, you're not raising an estate in Philadelphia County. And so, find yourself an attorney. And if you have trouble finding an attorney in Florida, you're free to give us a call. We'll certainly help to make that happen and to locate somebody for them in the county in which the decedent resided when he died. Okay?
Yes, thank you very much.
Katrina, thanks for calling Court Radio from Pottstown. Have a great Sunday. All right, well, maybe one more. Let's talk to Elizabeth from Overbrook. Hello, Elizabeth.
Hi.
Hi, how are you?
How are you?
Good, thanks.
Good.
So what's your question?
My question is, my mother added my name to the deed of her house. I want to know what the procedure is when she passes. I have two sisters. Currently, my daughter and my two grandkids live in the house. I would like to keep it that way, but I want to know what the procedure is as far as my mother passing and what happens after that to, I guess, process the house.
Yeah, well, I would be, I would say that, does Mom have a will?
Yes, and she has a will leaving the house to me.
Okay. And in fact, the house is now in joint names, yours and hers, so it will have been left to you. Mm-hmm. And then you'll own the house. You could do whatever you want with the house. You can have whomever you want to live in the house.
So you're telling me I'm not going to have a problem with siblings?
No, well, you may have a problem. That I can't tell you. Anybody can try to do whatever they'd like to do, but I will tell you that a parent can disinherit a child to the extent that they wish to do so, either completely or partially. And so, yes, your mom can leave you the house and not leave any part of that to either of your siblings or any of your siblings.
And if my name is on the house, but she hasn't left the house to me, how would that process go?
Same, because really the house would, in that instance, well, it really depends on how the house is titled. So you can title a house joint tenants with right of survivorship, in which case the person who survives, the last to live, gets the property. But you can also title a house joint tenants in common, in which case it literally is a 50-50 proposition. So you would own 50% of the house, and your mom's 50% would fall into the residuary of her estate. Am I lying, Saul?
You are correct.
Okay.
As a rule, between parent and child, there's usually survivorship, and when mom passes, you could then have a new deed prepared which reflects that you are the only record owner of the property.
But again, to be absolutely certain, you have to have that deed reviewed by an attorney to make sure it has the proper language so that when mom passes, it becomes yours 100%.
Okay, well, Saul prepared my deed, but I didn't never ask these questions because I didn't think of it.
There you go.
But you're giving me my answer now. Would I incur an inheritance tax?
No. Well, if it was in common.
If there are two names on the deed, mom's in your name, and mom passes away, at the time of her passing, you own only 50%. You're inheriting 50%, so there would be inheritance tax on mom's 50%.
Oh, there you go.
But if it's titled the other way, I wouldn't incur it?
No matter how it's titled, you would you would owe 50% of the taxes. You'd owe taxes on 50% of the value. But unfortunately, we got to go. We're all out of time. Thank you so much for calling. Have a great Sunday, Saul. Thanks for participating in another round.